married. Monday, I'm Mr. Dunston married for the applicant. My name is Mudomi Kenkodu for the respondent.
Sections 2, 6, 7, 8, 9, 12, and 17. Act 15, Section 133 of the Land Legislation Act, seeking orders as follows. The application is served by the agent, and he had expertise in the person sent on account of his agency. Pending the hearing and termination of this application, the respondent and his servants or agents be restrained from the victim or excluding the applicant, or in any way interfering with the applicant's peaceful possession and living in the matrimonial home and the hardship, stroke out either 38, Maua, and difference on the marriage, and the US number 16, elected on land difference 78, stroke 13.4, out number 127 of the Kiambu. That when the hearing and termination of this suit, the respondent and the servants agents be restrained from the victim or excluding the applicant, and all in any way interfering with the applicant's peaceful living within the matrimonial home, so grand request number Apache stroke Auki 1338 Mawanda verse the marriage county leaders number 16, elected on land verse number 775 1324. Item number 173 in the Kiambu. Pending the hearing termination of this application, the national temporary injunction is issued restraining the respondent, the servants and agents from wasting, damaging, or deleting or otherwise interfering with the matrimonial properties and the applicant's possession therein. At the end of the order, 45 310 at the Factory North 1074 1044 1044 1045 1006 and 1047 servants agents from wasting, damage, or limiting or sub or otherwise interfering with foreign matrimonial properties. Therefore, I find that it has no jurisdiction to issue and give so. The respondent went further to attach a judgment dated 3rd January 2016, matter 6 FML 2, divorcing the applicant from her former husband, one and not. Thus contending that the applicant had no capacity at the time, the alleged time to marry the respondent before solving a previous marriage with her former husband. The respondent not ever taken or assumed parental responsibility for the applicant's children, whom he referred to as being grown ups with their father taking care of. The father stated it was the applicant who chased away his children from Villa House on the 16th and not the other way around. Termed the applicant's lupus and malicious and the case threatened to deprive him of his property, which he single-handedly earned without the applicant's contribution. The respondent averred that the applicant had conceived material facts from the court by not disclosing that her first concern is now in school, and that Sharon Mariane maintained her overall facts. But still, the child named as Meru Senator is a daughter of the applicant's sister, hence he could not have assumed parental responsibility over her. Regarding the Runda and Meru matrimonial houses, the respondent attacked ownership of documents showing that he was the sole registered proprietor, thus denying any contribution from the applicant during the acquisition. He termed the claim contained the original summons as scandalous, frivolous, and an abuse of the court process. That the applicant has failed to disclose and multiple millions properties held by her children and companies as proxies. He named such properties located at Kiradasha one house and 4 houses would be in Saudi, among other properties. Concerning the number of property, the respondent claimed that it was ancestral land, and the house thereon was built many years ago, even before the arranged marriage. The respondent, however, stated that he met the applicant sometime in 2013 while working in the office of the deputy president. But around June 2015, the applicant requested him to temporarily accommodate in one of his houses, and also to establish a small office in one of the rooms at applicant's company head offices. That he allowed her to establish the office temporarily, and later 2017, he accommodated at his home on compassionate grounds, having lost her job. That The occupation was subject to conditions of living harmoniously with his children then staying there, not to tamper with any furniture, fittings, or documents therein, allow him unlimited access to the house, and also to exceed by 30th June 2018. He denied ever introducing the applicant to his family members as a wife. Although he admitted being accompanied by the applicant's various political rallies, he claimed that they had no connection with any marriage relationship. That despite that good gesture and in total breach of all the conditions set out, the applicant brought in her children and chased away his children from that home. As to the shareholding the listed companies, the respondent alleged fraud on the part of the applicant, who changed the directorship and shareholdings in the respondent's own companies in provision with the stock companies. He basically denied any contribution by the applicant or her children towards the acquisition of all the properties listed in the accusing service. Touching on funds held at Corporate Bank, Family Bank, Standard Bank, Citibank, and Equity Bank, the respondent denied contribution to the applicant or her children. The respondent informed the court that miscellaneous civil application number 10/4/2018 filed by the applicant against the respondent and the guise of protection against domestic violence, with exclusive occupation of the house by the applicant was dismissed on 11th December 2018 for want of prosecution. Hence, an episode of the court proceeded to seek similar orders in this court. Further, he averred that there is a pending divorce case at Meru Chief Magistrate's Court, being divorce case number 26/2018, in which the applicant is seeking to solve a non-existent marriage. He listed several other cases between them in which a dispute over the company properties is involved. In his submissions, Mr. Mudomi counsel appearing for the respondent basically adopted the affirmance contained in the primary judgment which is so detailed. In a nutshell, counsel submitted that the applicant has never been married to the respondent, and any known law under the respondent who is still under normal statutory marriage, which has never been resolved, would not have had capacity legally to contract another lawful marriage, be it customary or otherwise. You will find that this court cannot assume jurisdiction to determine matrimonial dispute where the existence of marriage has not been established. He further asked the court to find that all the properties are registered in the name of the respondent and that there was no proof of any contribution by the applicant towards the acquisition. Learned counsel admitted that the applicant was sometime 2017 accommodated by the respondent as a visitor on certain and clear terms, which terms were violated. Hence, the eviction without notice. He submitted the applicant to not require notice to exceed had been accommodated as a visitor. Analysis and observation. I have considered the application here as evidence in support with primary and all submission by both counsel. It is however worth noting that none of the learned counsel made reference to any authorities in support of the submissions. Nevertheless, the issues that render for determination are as follows. A, whether this court has jurisdiction to hear this application of suit. Whether there is a prima facie case established to grant the orders of injunction and preservation of property. Whether company properties can be a subject of division of matrimonial property in accordance with the Matrimonial Property Act 2013. Whether the eviction pilot out against the applicant was law. I've started additional point. Whether this court has jurisdiction to maintain the suit here. The question of jurisdiction is a critical component in legal litigation process. For a court to make any order or orders affecting parties and dispute, it must ensure that its proper consist of the authority to preside over such disputes. In the well-celebrated case and most frequently referred to case of owners of motor vessels, regarding the pending proceedings before the High Court Commercial Commission, touching on company affairs, those are independent suits to which this court cannot ventilate to determine ownership. Ownership with respect to the affected properties will be determined in accordance with the law governing disputes involving companies under the Companies Act. A company is a legal entity law capable of suing or being sued. I refer to the case of Salmon versus Salmon by the Company Limited, 1997. If there is any dispute over company property, the correct forum is commercial division. Concerning similar matters pending before the Magistrate's Court, dealing with Linear's civil case number 1044/2018 and 1260/2018, touching on protection against domestic violence and the execution of the respondent from the suit premises, the same are quite distinct in terms of the player's soul. This court has no jurisdiction to entertain any players touching on claims of domestic violence and the issue of exclusive occupation by any one party with the suit premises within the meaning of Section 3 of the Protection Against Domestic Violence Act. That is for the Magistrate's Court to determine under Section 24 of the said Act. Section 15 of the Protection Against Domestic Violence Act provides that a court shall not decline to to make protection orders simply because of the existence of other proceedings related to the parties. And the mandate in this case is to preserve their property in question and also protect parties' beneficial and proprietary interests of the same property by giving them equal opportunity to prove their stake in the same property. It is not for me to dictate who should visit who or who should not stay in the house based on allegations of domestic violence. The proceedings pending before the magistrate court do not affect the orders of this court insofar as preservation and division of real property is concerned. It is tried that the court should sparingly dismiss a suit unless there is a clear and absolute justification that indeed the court does not have to proceed. It is my finding that this court has jurisdiction to hear the matter, make a determination made after according to both parties an opportunity to make their case. These are parties of ruling law that no one should be condemned and hence they need to hear both parties and determine the case on merit. Whether there is a proof as case against a case to grant the orders of injunction and preservation of property in question. In this reported case of Hera versus Castle Brown 1973, that will report to appear page 358 and 360. An injunction order can only issue upon proof of prima facie case with the probability or likelihood of success, proof of irreparable damage that cannot be compensated in monetary terms, and assessment on a balance of convenience on which side has just changed in favor. See also the case of Woman Limited versus John Bond of Nielsen and two others, Court of Appeal number 7712, and the Kenya Commercial Finance Company Limited as a Private Education Society 2001 for 1 where the court held that all the three conditions and stages must be applied as separate, distinct, and logical hurdles which must be surmounted sequentially. However, I am alive to the fact that the exercise of such powers is a matter of judicial discretion, which must be executed judicially, and a mandate to promote the integrity of the court, bearing in mind that judicial power is delivered by the people of Kenya through the Constitution. The Court of Appeal alluded to the application of discretionary powers by the court while issuing injunctive orders in the case of Abel Salini and two others, versus SF Okomo and two others, 1976 Kenya report. As stated above, there is no dispute that the applicant has been staying at the Runda residence, Killer Home number 16, from where she was forcibly evicted, allegedly on being a staff of a visitor, who that the proverbial come of what accommodated but knocked out the owner. The applicant swore an affidavit and the reference supporting affidavit and attacked several to demonstrate that she had been staying with the respondent as husband and wife. She attacked photographs showing the two attending family functions and gatherings, including various of the restaurant. She also attached documents, among them an architectural drawing of the Runda house bearing her name. All this information prima facie formed that a probability that the two presented a lifestyle of a husband and wife for the eyes of an open person serving to prove upon hearing the main source. The evidence presented and the conduct of the two parties prima facie presents and makes a revelation of some form of husband and wife relationship which will only be proved or disapproved upon the hearing of the case. On that account, there is prima facie evidence with a probability of success, especially upon the proof that the husband had divorced his first wife, divorced his wife before contracting customary marriage, which is claimed by the applicant. With the applicant suffered variable damage in the order so they are not granted. It is common knowledge that if the property is preserved, the applicant will definitely suffer variable damage should the same change hands to third parties. The injunction preservation order so is therefore necessary in this circumstance. On appearance of convenience, justice demands that the applicant be given an opportunity to complete that case in court without being dismissed at the temporary stage. This is a sensitive matter which cannot be initially assured. For those reasons, the applicant has satisfied the threshold for the grant of preservation orders as well as injunction. C. Whether company property can be subject to division as matrimonial property and the matrimonial property at 13. Regarding company properties, I have already alluded to the same argument. The properties are government division to aptly consider and determine the dispute. This court will not interfere with that mandate to entertain a division of company properties. B. Whether the eviction was lawful. It's admitted that the applicant was forcibly evicted from house number 16 Runda, which she claims she jointly built with the respondent, and that she has been staying there since 2016-2017. The respondent has not denied evicting her. Termed the eviction as lawful and justified as the applicant was a visitor, requiring no notice to vacate. Curiously, this eviction was conducted on 19th December 2009. For avoidance of doubt, the motor vehicles in question, as mentioned in Prayer 7, shall continue being used by their current users but without changing ownership. To execute these orders, the OCS Runda Police Station is hereby directed to ensure compliance by providing security to the applicant during my return to the premises at Runda Villa number 16, and the security currently manning the premises and the instruction is for you to join, and the two to make mutual agreed joint security arrangements. Regarding course, this is an issue that has been arranged family affairs, which parties are there in course. Those are the others.
Much obliged.
Most obliged. Thank you so much.
Was Mariane Keittan's application to reinstate her back to the house. Her position was that in her affidavit that she's a wife legally married after divorcing. She was married under the Meru customary law. She has contributed into the building of the matrimonial home. She produced evidence in form of architectural designs in her name, titles of the land. The court had ordered a deputy registrar to go back to the house to inspect whether indeed she was staying there. When the registrar went to the court, evidence was found that her personal clothing, her personal belongings, her children's belongings, her presence was in that home, and therefore the court, according to the judgment of Justice Onyego, the court has found a prima facie evidence that indeed there's a likelihood that she's a wife. Mr. Linturi, Honorable Senator Linturi, has in court projected an image that Mariane Keittany was a visitor, and she had overstayed as a visitor, and therefore he had the lawful authority to evict her violently without notice or without following the due process. He has denied that she's not a wife. The court has found out that there is a likelihood she's a wife, and the question about who is a wife can only be determined during the trial by the parties producing evidence. The court has also found out that what Senator Linturi did to violently evict our client from the house is barbaric, is savagery, it is not part of the tenets of a modern civilized democracy as Kenya that is governed by the rule of law and the democratic principles of constitutionalism. And therefore that act of evicting somebody has been declared an illegality. Two, the act of eviction was conducted at the time when the matter was before the trial judge. And therefore the court found out that that eviction, the aim was to beat ends of justice. So that the court, by the time it is making the decision, it will be a decision that has been overtaken by facts. And therefore the court has put it very clearly that our client, Mariane Keittany, will go back to the same house. There are 2 or 3 police officers who are manning the house without any lawful court order. There are security people that are manning the home without any lawful order. The court has ordered the OCS Runda to ensure that our client goes back to our house, to the exclusive use of that house. The people called the police officers who are there to be evicted and new security apparatus manned by the OCS Runda to ensure that our client goes back to the house. And definitely it is the day that people, the courts have protected the rights of ladies, women who are being evicted out of a dispute between a husband and a wife. Then the women are dispossessed their properties. They are thrown out in a very savagery manner, but the court has restored the dignity of women, the dignity of children, and the dignity of career women who have contributed into development of matrimonial property. It is a crash to the patriarchal male chauvinist approach where women are thrown out, children are thrown out. The children of our client have not gone to school because they have not been able to access books. They have not been able to access their school uniforms. Therefore, we hope by close of business today, once the court has spoken, the lower court, the magistrates court, had spoken. The same instructions were issued, the same orders. Today we have now a final order coming out from the High Court, and therefore I hope that matter has been settled. My colleague, Mr. Kihanya, will top up.